All right, Mr. John?
Got a motion on the floor.
Oh,
So we
okay, I
have
got
a
a motion,
Mr.
for
Norman,
him to
did
go
you
along with the
withdraw your motion?
hospital. I got a second. Do I have a second? Do I have a second? Do I have a second?
Ready? Morning.
Good morning.
Got the September financials here. This is the last month of the year. I want to start with the income statement. Like Mike said, we've had finally have gotten the general ledger system to where it's workable. So I've done rapid fire 3 month-end closings here, and we're going to come and talk about September this morning. I want to look at the income statement first. That's showing a bottom line in the month of September of $143,000 to the good. 2 primary things happened there. One is when we filed our, you want me to wait till you get there?
That should be, what are we doing?
Income statement, September.
Income statement.
Income statement, page 67.
Okay, I see it. Up in here at the end of it. Right here.
Okay, all right.
Okay, left-hand column is September, the month of September. At the very bottom, $143,000 profit for the month. There's 2 main things that cause that. Number one is we have a $94,000 Medicare payment in this month because that is from us filing our 2015 cost reports. That's an adjustment for 2016 rates, so that is legitimate revenue in 2016. Also, meaningful use, Mike said we had $340,000 cash received. We did. But we had about 300 of that reserved for already as set up as receivable. So we had another $34,000 pickup on that. So those 2 things right there account for $128,000 of the $143,000 profit for the month. Skipping over to the year-to-date column of September, you'll see the bottom line there is positive 18,855, basically a break-even year. And comparing that to September of 15, again, it's back-to-back 2 break-even years. I won't talk about that in just a moment. On the year-to-date column, both on the right, both looking at September 16 and September 15, you can see that we're having to write off about 52% of our revenue due to contractual adjustments and uncollectible accounts. The operating expenses are there listed, side by side, and like the earlier question about payroll, that's the first line item under operating expenses, so you can see where it was in 2015 versus where it is in 2016. 3.7 million versus 4 million, and that answers one of your all's earlier questions, which I think Mike did address also. Looking at the balance sheet, we've got, like Mike said, 23 days cash on hand. I know there's also some liabilities here, such as the healthcare trust fund, accounts payable, and so forth. So at some point in time, the days in cash hand could go down, and also the liabilities would go down. But as we ended the year on September 30th, this is what our numbers are. We've got the $513,000 of cash in our operating account. We are also anticipating, you mentioned the lip and dish funding, possibly ending July 17. We've got our lip and dish funds are projected to go up this year by about $600,000 conservatively over last year. So that's something to look forward to. Now,
Commissioner, since you brought up the funding and that we had a discussion earlier about that, I did want to address it a little bit more. About 2 weeks ago, I made several phone calls to the Florida Hospital Association requesting an update on where we were at with LIP funding. Should we be making contingency plans for it not coming in, or at what point did they expect it to start coming in? Because as Commissioner Sanders mentioned, no hospital has gotten LIP or DISH funding since July, or we got our last funding in June. So this fiscal year for for the state, nobody has received any dish money or LIP money. For us, that's about $110,000 to $120,000 a month. The report that I got, and when I got off the phone with FHA, they called ACA to, get a report from them directly. And the response was that they still had not, and this was the very 1st of October. So they said they didn't expect anything in October, but that the IGTs, the intergovernmental transfers, which is what, hospitals put money in, et cetera, they had not done those yet, but they were going to do them. They were going to do them in October. They can't disperse any money until those IGTs go in. They had hoped that they would get money out in November. FHA relayed to me, if ACA says they hope for November, expect December. So that is the latest report that I have. That was 2 weeks old as we sit here. So that's where we're at with LIP and dish funding.
You think they got that kind of money to send all across the state?
Actually, yes, it'll get funded this year. As Commissioner Sanders mentioned, the issue is not with the money, because most, that money is matched. It's matched by the federal government. And in the past, these big hospitals like in Miami and Jacksonville, particularly the big safety net hospitals, they've put up hundreds of millions of dollars, and they send it to Washington. Washington matches it, but then these big hospitals take their $100 million back, and then the other $100 million gets distributed around the state. Well, that's where the feds have said they don't want that to happen anymore, but it's going to happen this year. And to replace that, what they're going to ask is these counties to do the IGTs as opposed to the individual hospitals. So that's where we're at, but it'll get funded this year.
I believe they're gonna hold off on it as long as they can to keep from having to pay it though. I really do.
Let me continue on speaking about cash today. Mike mentioned we put $360,000 in the money market. That represents 2 payrolls and 2 payments to our emergency room doctor company. So that's there for that. Today, we're meeting payroll without dipping into that, and we've got about $60,000 left after that. Also on the balance sheet, I know that the healthcare trust fund amount is what it is at $890,000, but the accounts payable that we pay our vendors is trending downward too. So yes, we do want to pay back the healthcare trust fund as we can, but we also don't want to keep coming back and forth to you. So I feel like now that we've got a general ledger system, we have a better idea of where we're at day to day and month to month, which in the past 2 or 3 months, we've been sort of flying in the dark without this report in this document. Also, I have learned yesterday how to get something out of the system. I will send you, I'll email every one of you a report on the ambulance. This system is able to give us a departmental income statement by each department. So I usually would have had that for you, but I just now learned that last night. So before the day's over today, I will send you an update on the ambulance income statement through the 12 months. And that's my report. I'll be happy to entertain any questions.
John?
Just one question. We are gonna get the new ambulance in November?
Yes.
Do y'all know about when?
I talked to Jared about that. I talked to Jared about that right after he gave his resignation. And he didn't have a date, but he said he had just been in contact with them, and that he had ordered them to go ahead and put the logos and stuff on it. So when it gets here, all we got to do is move stuff into it. We won't have to send it off to get the paint and logos, et cetera, et cetera. But I don't have a date as of right now.
I got one quick.
Go ahead.
Mr. John, what about your vendors? How you with them?
We're dealing with them by always communicating with them making promises on specific times and following through with those promises, and we've caught several up. It's an ongoing process. We'll still keep doing that. Our drug vendor, for example, we've reduced their amount that we owe a lot. That's one of the ones that, dealing with big dollars, they call, once a week at least, and we always try to at least always return the phone calls and give them a legitimate, correct promises when we can do something for them. And they're all, bless their hearts, they're all thankful for what they can get, so.
Yeah.
Communication's so important to that. We just have to keep them abreast of everything too.
Some better than none, ain't it?
Thank you.
Any more questions for Mr. John? Thank you, John. We're going to take a 5-minute recess.
So you can let him speak first and then
Yeah, I'll get her because he had his hand raised. The Board of County Commissioners is now back in session. Speak your name for the record, please.
Good morning, Commissioners. My name is Wendell Barfield, Jr. I'm an employee at Weems, but by no means do I represent Weems or any of its business. I'm speaking on behalf as a concerned citizen. Speaking of the clinics, I set up the clinic in Apalachicola. I worked extensively in the clinic in Carabel with Dana Whaley and Dr. Charbonneau. And yes, it was an urgent care clinic. We did do sutures, we did do wound repairs, we did do people that came in with broken arms, and emergency room services we did provide there. If it was extensive, we did ship over to Weems ER. Now, on saying that, with the physician that's currently there, she has come to me personally and spoke horrible things about my cousin, Dana Whaley. And I have worked with Dana, and I have never seen Dana act in the fashion that this provider was saying. I've seen her refuse patients while I've worked over there. I helped Miss Gibson. She asked me to work over there in the capacity to help them while they were short because they had several nurses quit there. And while over there, she said things that were beyond even what I can tell you, like all handicapped people shouldn't even be allowed to drive. Things of that nature, which were totally off base. This woman really needs to go, in my opinion. I think it's horrible how she's treated our county constituents in this county, and I think it's deplorable, her actions. I think also that in a brief history, Mr. Cooper stated he wasn't here for this, but I was. In the brief history since Dr. Charbonneau has left, they had a doctor that was going to come that couldn't pass a drug test or was willing to take one and did not show up. In the interim, they also had these agency doctors they were paying exorbitant amount of money for on a daily basis before finally selecting Emma Stoll, who is there currently. I have had so many people in the community come up to me and complain of the deplorable action that she has in treating them, that she turns them away, that she won't refer, that's not her job to do that. That Dana has, my mom recently had to have her Ogen filled, which is medicine that she takes, and Dana had to tell her she didn't know if that doctor would do that for her. Dana can't even act in the capacity that she needs to be able to act in due to that. Also, this doctor does no sutures, nothing that's urgent care, doesn't participate in anything of that nature. I would really, as a concerned citizen, like to ask the board to even consider, since they're wanting to replace this doctor, bringing Dr. Charbonneau back, because he was a good asset for this community and a good fit and would love to come back. And that is my question to y'all today.
Thank you.
Thank you.
Yes, ma'am.
Good morning, Commissioners. I'm sure you all know who I am. Kristen Bell, registered nurse, and I'm currently employed at Weems Memorial, ER as well as Med-Surg. I stand here with a heavy heart for my nurse staff and my EMS staff. You guys aren't going to have any staff. They're quitting. They're walking out the door. We don't get retirement. We don't get lunch breaks. Yes, I've emailed my management team about it. You work 12 hours in an ER shift and you don't eat? Guess when medication errors happen? When nurses are hungry, stressed, and tired. Our raises were taken back, and I understand the situation. You had no choice. I understand that. You had to rescind everybody's. I get that. Some people didn't understand that. Our raises were taken back. We don't make as much as other hospitals are paying. There's no 401k or retirement to take care of your family in the future. There's no lunch breaks. You tell me what an incentive is for a nurse to come here and work. We can't build a new hospital because we can't even fix what's broken at our old hospital. And I weep for the residents of this county because they're the ones that are suffering. I have a job as a nurse to take care of these residents, and we can't do that with a skeleton crew. So please reconsider. I know that you have told Cooper to go back. The time's now. We can't wait to give these raises back because your staff's walking out the door one by one. We've had an EMS director, Dr. Charbonneau, a receptionist at the clinic in Carabel, 2 nurses resigned this week, and a housekeeper. That's a lot of staff. That's a lot of people. Our healthcare system is failing right before our eyes, and everybody's so worried about money and greed and raises that nobody's doing anything to me but bickering. Please help it before this hospital closes and we have no ER and we have no way to take care of these patients of this community.
Thank you. Michael, planning and zoning?
If you don't mind, could we let the
I meant
clerk
Marcia, okay, I'm sorry.
go and then, because she has a meeting now.
Oh, okay.
I appreciate y'all taking me. I do have a lunch meeting I've got to be at. I have 6 resolutions for adoption on unanticipated revenue as part of the end-of-year bookkeeping in my office. This involves funds that weren't included in the initial budget for the last year because we didn't know at the time those funds would be received. And approval is needed to comply with the Florida statutes. The first resolution dealt with $9,000 we received from Duke Energy for payment of expenses relative to the Sea Oats Initiative grant. The second resolution deals with $50,000 received from the State of Florida Department of Environmental Protection for payment of expenses incurred in the FERDAP Vrooman Park improvements. The third resolution deals with $5,720 received from Florida Division of Emergency Management for the payment of expenses relative to the CERT program at the EOC. The fourth resolution deals with $63,658 received from Florida Department of Transportation for payment of expenses relative to the local area program sidewalk projects. That was the Bayshore Drive sidewalk and Tallahassee Street sidewalk. The fifth resolution deals with $25,000 received from Department of Economic Opportunity for payment of expenses incurred in the GIS mapping project. And the sixth resolution deals with $238,601 received from the Florida Division of Emergency Management for payment of expenses relative to the Residential Construction Mitigation Program. And that's where citizens were getting some help through EOC for housing projects.
So moved.
Second.
Have a motion, second on the floor, all in favor? All opposed? Motion carries.
And I may have some more resolutions at your upcoming meetings as the finance office is trying to close out the year. Thank
Okay,
you.
Thank you, Marcia. Now, Mr. Michael.
That'd be me. Okay. Let's do the planning and zoning report first, or as some like to say, the Dan Garlic Show. Item number 1, recommended approval for consideration of a request to construct a single-family dock at 4042 at St. Teresa Avenue. They have applied for the state and federal permits and meets local requirements. The dock walkway will be 423 by 4 with a 20 by 8 terminal platform and 2 boat lifts. Request submitted by Garlic Environmental Services, agent for Russell and Susan Turner.
So moved.
Second. Have a motion, second on the floor, all in favor?
Aye.
All opposed? Motion carries.
Item 2 is consideration of a request to construct a single-family dock on Lot 11, Block 57, Unit 5, 315 Bruce Street on St. George Island. They've applied for state and federal permits and meet all local requirements. There'll be a 6x4 boardwalk over wetlands, and then a 14x4 access walkway, and a 10x20 terminal platform with a step down to a 12x20 uncovered boat lift. Request submitted by Garlic Environmental Associates, agent for Teresa Chasen and Diane Young. They're the applicants.
Move for approval.
Second.
Have a motion, second, all in favor? All opposed, motion carries.
Item number 3 is consideration of a request to construct a single-family dock, Lot 18, Block 71, Unit 5 at 315 West 8th Street on St. George Island. They've applied for state and federal permits and meet their local requirements. There will be a 49 by 12 deck with attached 10 by 8 finger pier between the 2 covered boat lifts. Request submitted by Garlic Environmental Associates, agent for CU at the Canal, Joel Ulrich, the applicants.
Move approval.
Have a motion.
I need to
Yes, ma'am.
ask a question about
Yes, ma'am.
this. Where do we stand on covered boat lifts? And covered
As
docks?
I'm sorry, as it applies to, if there's a
Where do
restriction
we
on
stand?
it?
Because I know on Alligator Point, we don't have covered docks out there at Alligator Point. That's the reason why I asked. Go ahead, Dan, can you answer? I mean, I don't have
Commissioner-
anybody right here to answer for me.
Yeah.
The board passed an ordinance probably 3 years ago specifically for the Alligator Point area. That ordinance does not apply in any other part.
Any other
of the
place?
Yeah,
county.
it
That
was,
is correct.
because of that, the complaint of the terminal and blowing, yes.
Yeah.
That's those strict.
Yeah, that's the reason why I wanted to know, because I'm starting to see more covered boat lifts and more covered docks, and that's
Yeah,
why I'm asking.
Yeah.
A lot of those are limited by DEP as well in the different aquatic reserves like Apalachicola Bay. The Alligator Point thing is a little bit unique because
Yeah.
a lot of the area is prohibited, so you could have docks there, but then we're basically trying to follow the best we can to,
Yeah.
make sure we're good with the county.
I like to just have an update because that's important to know that. Okay,
I'm sorry, we got a motion for approval of 3?
in a second.
Okay, all in favor?
Aye.
All opposed, motion carries.
The consideration of a request to construct a single-family dock, Lot 1, Block 57, Unit 5, 355 Bruce Street on St. George Island. They've applied for the state and federal permits. They meet the local requirements. There will be a 145 by 4 walkway with a 26 by 6 terminal platform with 2 17 by 20 boat lifts. Request submitted by Garlic Environmental Associates, the agent for Billy and Judy Blackburn. They're the applicants.
Move approval.
Motion second on the floor, all in favor? All opposed, motion carries.
And finally, consideration of a request to construct a single-family pair at 109 South Bayshore Drive in East Point. They have applied for state and federal permits, and they meet all local requirements. There'll be a 200 by 4 walkway with a 16 by 10 terminal platform. Request submitted by Garlic Environmental Associates, agent for Jessica Lewis Garcia. They're the applicant.
Move approval.
Motion second on the floor, all in favor?
Aye.
All opposed, motion carries.
Thank you, Commissioner, so much. And if we'd like, we can move right into the Board of Adjustment report,
There you go, go
Commissioners.
ahead.
Item number 1, it was recommended for approval, consideration of a variance request to construct a seawall within a 50-foot critical habitat zone, as well as placing a 5,497 square feet, .013 AC, 102 CY, help me out with that, based on average of 6 inches of fill of clean sand within the setback, coastal hazard zone setback. The sand will fill in areas impacted by Hurricane Hermine. The property is located at 315 and 319 Bruce Street, also known as Lot 10 and 11, Block 57, Unit 5, on St. George Island. The property is owned by Benjamin and Teresa Chasen. The request is submitted by Garlic Environmental Associates, their agent for the homeowners.
Mr. Chairman, if I might,
Yes, sir.
one of the conditions that the Board of Adjustment had added in here, and they refer to it as clean sand. The specific instructions from the BOA were that the clean sand be consistent in color, size, and material to what's already there. I think kind of goes back to what Commissioner Sanders said at the last meeting where you had some dirt
The black
being put
dirt.
on the side of the road that was not consistent with the materials that were already there. But I think that's what the intent was when staff wrote clean field sand.
So moved. Second.
Have a motion second on the floor, all in favor?
Aye.
All opposed, motion carries.
Okay, item number 2. It was recommended denial by the county attorney and our county planner. The Board of Adjustment recommended approval based on a 2-to-1 vote. It's a consideration of a request to appeal administrative decision regarding a non-conforming use in C4 zoning district to allow for 2 residential rental units and to allow 2 separate electrical meters and 2 separate water and sewer meters. This property is located at 4 3rd Street. It's in East Point. The request for appeal is presented by the property owner, Ms. Margarita D. Arellano. Am I correct there?
They are, Orlando, yes, and I'm local attorney Christy Branch Bates here representing the property owner today.
And Commissioner, I'm sure you're going to want to ask Attorney Schuler why.
We will ask Mark to step in, he has the planning.
I will.
official.
Tell him to bring a map if you don't mind,
Okay.
of that area.
You step on up to the podium, Christian, and get ready.
And if I may approach, I have copies of some items I'd like to share.
Okay.
with the board.
Go
Oh, you
ahead.
do.
You can hand them out, you got it.
Mark can be right in. He was meeting with the CRS person is here, meeting with Mark and Amy for our rating today. Let me see if I attached, what was attached on your packet, Commissioner. And I apologize, I just attached it without looking. He'll be right in. I see the application, and just a letter,
I'll get on here and get up.
additional letter. Let me see Attorney Schuler. When you, they're not talking about this type of map where they indicated it right here.
Yes, that's what they're talking about.
Is that good enough for the board?
It's up to the board, they probably want something big enough.
On
to
page
see.
104, Commissioners, on the packet, on your iPad.
What's the street? It's Highway 98.
East Point or St. George Island?
East Point.
I can describe it for you if you like. You may.
Christy, let me ask you a question. Is this East Point or St. George Island?
This is an East Point. This is,
That's what I thought.
I've always thought of this house as sort of like the carriage house. It's a 2-story, right across the street from the water, just past the last seafood house there on the left. It's on 4th Street, right there on the corner, has a little white picket fence around it.
It's 4th and 98.
You see the lots?
I think corner of 4th and 98, or 3rd Street, excuse me, 3rd Street.
Third and 98.
Street, that's what I'm saying, 3rd Street. And it put me on the island for some
Little white
reason.
2-story house, white picket fence around it.
Okay, I see it now.
There you go.
Okay, good.
That's right. Those
Gotcha.
right there highlighted.
Gotcha.
And before we get into the substantive issues, just let me lay the procedural groundwork for you. Typically, the Board of Adjustment, its job is to grant variances from your building code. In this case, they were not sitting in that capacity. The other capacity that the Board of Adjustment sits in is basically as an appellate function for decisions made by your planning staff. And in this case, Mr. Curington recommended denial of the application, and then there was an appeal filed of that administrative decision to the Board of Adjustment. So what you're doing now is you're going to determine whether to approve the overturning of Mr. Curington's decision or to affirm the decision of the Board of Adjustment.
That's all the history of it. Okay.
Mr. Chairman, if you'll just let Mr. Carrington know when the board's ready to proceed.
Yes, sir.
Okay.
Sure.
Just wanted some history of what they made.
Some history on it.
On the building itself, or?
Reason y'all was against it?
Well, I've recommended that we not issue the permit because it is it's a duplex in the C4 area, which allows single-family houses, but it does not allow multifamily residences. And there's an existing, it's a existing duplex, but they're on one meter. So I thought that adding a second meter would make it even more non-conforming. And so that's why I recommended that we not issue the permit to add a second meter to this duplex. They're operating under 1 meter now. Adding a second meter would just make it that much more non-conforming. It's not going to increase the density that's there now, but it will make the building more non-conforming. And that was the reason I recommended against it.
Is that the same, Mr. Chairman?
Yes, sir.
Is that the same reason the county attorney was recommending denial also?
Yes, sir. For that reason, and also we worry about, or I'm concerned about setting precedent for all the other C4 properties in the county. What you end up with here, and maybe I'll say it my way and not in Mark's technical way, you've got 2 residential uses on this current non-conforming use, and that's the reason they want 2 meters. C4 doesn't allow for 2 residential uses. It can either be a mix of residential and commercial, it can be pure commercial, or it can be, as Mark said, 1 single-family residence, but it can't be 2. Right now, it's 2, which is a non-conforming use that is, predates your current code from the best information available to your planning staff. And so that is the reason for the denial of the application for the second meters, because your C4 doesn't allow for 2 residential uses in 1 building.
So basically, if it's a non-conforming use, being it was there pre-existing the plan, so it's basically grandfathered in as it is.
Correct, and under your zoning code, you are allowed, on non-conforming uses, you're allowed to make, reasonable repairs and maintenance, but not improvements. And in Mr. Carrington's view, and I do support it, adding a second meter base, adding a second water connection, adding a second sewer line, that's an improvement. That's not a maintenance, that's not a repair of a non-conforming use. So I think that may be where the Board of Adjustment got a little bit confused in their role, because 99.9% of the time, they're in the role of saying, well, there's a hardship if we apply the rules, so we have the authority to grant a variance, and that's what, in my opinion, that they thought they were doing. And actually, what they were supposed to be doing was reviewing the correctness or the incorrectness of the decision of the building official, and not just saying, well, if we apply the rules, it's a hardship, and therefore we can overturn the building official. In this case, excuse me, not the building official, your department head for planning and zoning. In this case, what should have happened, and what you're here to do, is if Mr. Carrington has made the correct interpretation of the code, and there's not a basis to overturn it, whether it's a hardship or not, doesn't matter. If he made the correct decision, that your job would be to uphold his decision. If there is a basis for him to have made a mistake in interpreting the code, then you'd be in a position to overturn his decision. So that's where we are now. And I joined into his recommendation because I looked at the code, based on the facts that are available to us, I believe that Mr. Carrington has correctly applied the code in this case. Non-conforming use, they should not be making improvements to the building. They can make repairs, they can do maintenance, but they can't add different meter bases to it.
They've already
Hear
done.
from
These meter bases, they've already added them?
Apparently, at some point, there was a second meter base, we are told. We have no evidence that they ever got a permit for a second meter base. But at the present time, there is only 1 meter base. We don't know at what point in the past they had a second one. We looked through our records, can't find any evidence that they ever applied for or received a permit from the county for a second meter base. But as it is now, at the time she purchased the property, it had 1 meter base.
Can we hear from Ms. Banks about
Yes,
the
sir.
justification?
Is there any questions that the board has?
Anybody got questions for Michael Schuler, attorney? All right, you want to listen to Ms. Christie? Okay.
Thank you for allowing me to speak on behalf of the property owner. To give you a little bit of history, this property at some point in time was subject to a foreclosure action. There were some subsequent owners of the property. My client purchased it, we closed on it last month. And if I could just refer you to, and I am, with all due respect, of a slight difference of opinion as to the counsel that you've been given, and I would like, thank you for giving me an opportunity to point out some things that I would ask you to consider. The property is in the, it is in the C4 mixed-use residential, which section refers to Section 420 for non-conforming uses, and there's very specific language in 420 subparagraph 2 that gives the board the discretion to make the decision that my client's asking for. Essentially, the board does have authority to approve such improvements that result in bringing the structure into better conformance with the standards for the district in which it's located. So the mixed use would allow either 2 commercial or 1 commercial run residential, or in this case, it is grandfathered in because the county views the uses as residential. So what I would like for you to please consider is that there are 2 tenants. And my client, by the way, is doing this at her own expense. She's not increasing the rent or what have you, but the tenants have expressed an interest to utilize the 2 separate boxes. So what I'm suggesting to the board, and what I hope is giving you some basis to make the decision that we're requesting, if you would please consider that the couple, the Edwards that reside in the downstairs unit, actually have J&W Edwards Construction LLC, and he operates his business. It's more of a handyman business, I believe, type business. I don't think he's a general contractor, but I think he does more smaller projects. He operates that business out of his home. So I would suggest that there is some notion that there is a commercial use that's going on. His entity is set up with a principal address of 4 3rd Street Apartment A. That's downstairs. So I would concede that he doesn't have, I've not been there to see if he has an actual office set up for the public, but what I'm suggesting is that he certainly is operating his business out of this location, and the zoning would allow him to do so. The second tenant that's upstairs is, in my mind, much more akin to a hospitality nature type of accommodation, much more so than what you generally consider residential. The 3 tenants, I've included for you a page from the lease agreement. Actually, my client cannot have keys or access to this property while these tenants occupy it because they are 3 FWC officers who primarily reside elsewhere. You've got Ryan Miller, who lives in Palmetto, Florida, Eric Fletcher, whose home is in Tallahassee, Florida, and Gregory Medichek, who lives in Navarre, Florida. So all 3 of these FWC officers use these premises as a place to stay while they're here on duty working within the county in their capacity as an FWC officer. And I liken this to the situation that you have over at Sellers Tile. The ambulance service leases a space in a commercial building, and those folks reside there. I know my office is 2 doors down. I get to meet them. They live there for the 3 days or so that they're on duty. So I'm suggesting that the commission has the authority to grant this request because I believe it's a reasonable request. I don't see harm in granting the request, and I'm explaining to you that it's not typical residential use. You've got, the landlord is not even allowed to access the premises because you've got law enforcement officers with handguns and weapons, and therefore she's not permitted to go into the premises. And from what I understand with her, she's spoken with someone in personnel department and anticipates that this will be a long-term arrangement because most of these FWC officers don't actually reside here in the county, and there's very little leasable property for people who need to lease something as opposed to purchase it and live there full-time. The third picture is, at some point in time, and this is why I'm urging you, please, I think it's fair and equitable to grant this request. At some point in time, there were 2 utility boxes there. I don't know when, can't figure out at what point in time they ceased from using them, But at some point, this is a photo from the property. There are 2 boxes there. Now, my client has hired services of a professional electrician, Jerry Priebus Electric, Inc. He's inspected both boxes, and he's indicated to her that there's no question of functionability. At some point in time, they both were functionable, but at some point in time, someone discontinued the use of one box and put everything in line with 2 boxes, and put everything in line with the 1 box. So according to the electrician, all she needs is approval from the county for Duke Energy to come out and separate those bills. And her tenants have an interest in that as well, because, and I think that's actually her handwriting at the very bottom, theoretically, if you're operating a business out of a home, some portion of your expense is a business expense. I think these officers with FWC, this is just additional, the lease is with them individually, so there's additional expense for them that perhaps is housing related in connection with performing the duties of their job while in Franklin County. So what I'm suggesting is that my difference of opinion, and yes, attorneys very frequently differ in opinion, with all respect to Mr. Schuler's opinion, I suggest that not allowing her to separate the 2 boxes and let the gentleman upstairs have their bill, which is just their bill that they incur, and the couple downstairs operating their mom and pop business out of the home have just their bill that they incur, that in fact is denying them the ability to further what you would have intended in the ordinance. And going back to the language in 420, nothing in this ordinance is intended to prohibit such routine repairs and maintenance. There's a reference to health and safety. And then the ending of that paragraph reads, or such improvements that result in bringing the structure into better conformance with the standards for the district in which it's located. So I would just say that you do have a gentleman operating his business. You do have 3 officers, law enforcement officers, who are here only when they are on duty. Again, very akin to the residence and seller's tile for the ambulance service. And my client is in an attempt to be fair and equitable with her tenants, is asking for permission to separate the utilities and have them applied to the 2 separate boxes that are already in place, so those folks can each pay what is their own bill, and they're not splitting a bill with no ability to know who incurred what expense. And again, I do suggest, and I don't think it's been represented otherwise, that this board does have the authority to grant this request. And I would ask, please, that you do so.